Gentlemen of the press, you are welcome to Osun State Government House. I'm going to take my time to address you. I call this press conference to alert the national global audience about a deliberate plot to create chaos and anarchy in Osun State. I invite you all to expose a faceless anti-democratic agenda designed to enforce a non-existing court judgment on our local government. This evil plot is being spearheaded by the Minister of Marine and Blue Economy, Mr. Gboyega Oyetola, in active collaboration with Osun State Commissioner of Police, the Osun State Director of DSS, and the State Commandant of the Civil Defense Corps. Before I continue this address, let me affirm that I know Mr. President to be a true Democrat, a lover of rule of law, and a believer in the sanctity of the judicial process. I know, as a matter of fact, that Mr. President will never authorize a dictatorial violation of the Constitution irrespective of who is involved. It is crucial to add that Mr. President will never support any action that is capable of generating bloodbath and bloodshed. I, however, regret to inform Mr. President and the public that Mr. Gboyega Oyetola has concluded an arrangement to cause mayhem in Osun State starting from Monday. He is issuing illegal directives to security operatives to enforce illegality simply because he is nephew of Mr. President. I choose to alert the nation before my people are killed or maimed by a minister dropping the name of Mr. President in connivance with the Osun State security operatives obeying unlawful orders. The bone of contention is the brazen effrontery to return to office council chairman sacked by a substitute court judgment using a different court decision, which has no consequential order. Let me make it clear that the said council chairman was sacked before I was sworn in as governor of Osun State, contrary to the lies being peddled that the chairman and councillors were sacked by my executive order. For emphasis, I want to state that I had nothing to do with the sacking of the chairman and councillor produced by the Osun 2022 local government polls. The chairman and councillor were sacked by the two different judgments of the Federal High Court, Osogbo. The script Mr. Oyetola is playing is about the most reprehensible abuse of power in this Fourth Republic, capable of untold and unforeseen consequences on the polity. The general public is aware that there were two different Federal High Court judgments on the local government election of 2022. The first judgment was on the suit filed by the People's Democratic Party, PDP, which sacked the product of the 2022 polls. The second judgment was on the suit filed by the Action People's Party, APP, which also sacked the chairman and councillor produced by the said 2022 Osun local government polls. The APC appeal against the judgment obtained by the PDP was partially successful, and the said judgment was struck out based on the timing of filing. Having been filed before notice of election was published. It needs to be emphasized that the judgment contained no consequential order. In his amended notice of appeal, asked the Court of Appeal to reinstate the sacked chairman and councillors, but the Court of Appeal, in his wisdom, said it has become an academic exercise. The request for the reinstatement of the chairman and councillor was not granted. However, the appeal by the APC against the APP judgment did not succeed at the Court of Appeal, which makes the judgment still subsisting and alive. The Court of Appeal dismissed the APC appeal against the judgment obtained by the APP. The only legal recourse open to the APC is to appeal the APP judgment and the subsequent ruling of the Court of Appeal to the Supreme Court. The certified true copies of both judgments had earlier been forwarded to the Osun State Commissioner of Police, the State Director of DSS, and the State Commandant of Civil Defense by Osun State Attorney General for their information and record. The certified true copies of both judgments are in the public domain. The judgment of the Court of Appeal on the PDP case was not ambiguous whatsoever. It simply struck out of the PDP suit and did not, in any of its paragraphs, order the reinstatement of the sacked council, chairman, and councillors. It is very clear that no consequential order was made before the APP case is still subsisting. As I stated earlier, the Court of Appeal said that the request of the reinstatement of the chairman and councillor has become an academic exercise. We call on legal luminaries and the Nigerian Bar Association to fact-check our claim by reading and interpreting the judgment. Even as a layman can comprehend the meaning except those with an agenda to destroy peace and progress of Osun State. In a democratic society governed by the rule of law, we all must submit to the law. If we are dissatisfied with the outcome of a court process, we can appeal to the next court to end at the Supreme Court. If you are not sure of the meaning and intent of a court judgment, the system expects you to apply for interpretation against true court system. It is illegal, unconstitutional, and anti-democratic to take the law into your own hands. For a serving minister, the person of Mr. Gboyega Oyetola, to lead charge to violate the Constitution and foment violence over a judicial process is not only shameful, but is sadism and treason taken too far. We have it on good authority that Mr. Gboyega Oyetola has instructed the Osun State Commissioner of Police, the State Director of DSS, and the State Commandant of Civil Defense Corps to mobilize security operatives from within Osun State, effect the non-existing judgment by forcefully taking over the local government on Monday. Mr. Oyetola and the police boss have been holding a series of meetings on how to effect the illegal operations. We affirm that Mr. Gboyega Oyetola has no constitutional authority to issue directive to the security agencies. The fact that Mr. Oyetola is nephew of Mr. President does not confer any such authority on him. We see this as a gross betrayal of trust reposed in the Osun State security officers by the Constitution of the Federal Republic of Nigeria. I want to state that the current nefarious activities of Mr. Oyetola and bosses of Osun Security Agency constitute great incitement. This needs to stop because we are neither interested in resorting to self-help nor in support of violence to resolve political matters. As much as we are law-abiding people, we are fierce protectors of our rights at night and by the day. I want to place on notice the Nigerian public and our friends in the diplomatic community and the lovers of democracy and rule of law that our people will not accept any attempt to impose illegality and anarchy on us. We will not allow any takeover of local government except through a judicial pronouncement or democratic process. We vehemently reject any ploy to deploy non-existing court order to achieve local political power. I repeat, we vehemently reject any ploy to deploy any existing court order to achieve political power. I therefore appeal to Mr. President, who is a renowned Democrat, to insist on the rule of law by instructing the Inspector General of Police, the Director General of DSS, the Commandant General of Civil Defense, Corps not to obey an illegal order from his nephew, Mr. Gboyega Oyetola. The Osun State security chiefs should also be called to order. I call on Mr. President to instruct the National Security Advisor and the Attorney General of the Federation to personally verify the fact the Court of Appeal judgment did not reinstate the sacked local government chairmen and councillors, and the fact that there is a subsisting judgment of court that sacked the chairman and councillor produced by the 2022 local government polls. The Nigerian public should hold Mr. Gboyega Oyetola and the Osun State security chiefs responsible for any breakdown of law and order in the state tomorrow, Monday, and beyond. It is unfortunate that the Osun State security chiefs are taking instruction from Mr. Gboyega Oyetola just because he's the nephew of Mr. President. It is not acceptable. As much as we do our best to maintain peace, we call on men and women of goodwill to intervene before it's too late. I repeat, as much as we will do our best to maintain peace, we call on men and women of goodwill to intervene before it's too late. I thank you all for listening. And now, I will call on my Attorney General, Mr. Bada, to further explain and expatiate before my Commissioner of Information will address you to. Over to you.
Page 34 of that judgment contained the 4 issues for determination that was before the Court of Appeal. And at page, issue 1 deals with the amendment that the Federal Court granted to PDP, portion to the application filed by PDP before the Federal Court. Then issue 2 talked about, it borders on the time at which the PDP brought the action, if it is premature or not. And the Court of Appeal at page 49 and 50, the last paragraph of page 49, if I may just read out. Now, since it is the position of this court that there is no valid originating process to confer jurisdiction on the lower court to hear and determine the claim of the first respondent, there's no point in considering the remaining issues. A consideration of the two remaining issues has now become an academic exercise, which this court is not prepared to venture into. The two remaining issues not considered are the issues on restating the sacked chairman and councillor by the Federal High Court, Osogbo. The Court of Appeal did not consider because it is academic and is not prepared to venture into same. The Court of Appeal went further. In the circumstances, the resolution of the two issues in favor of the appellants, in the circumstances, with the resolution of the two issues in favor of the appellants, it follows that this appeal is meritorious and it is accordingly allowed. The amended originating summon is hereby struck out for incompetence. Consequently, suit number FHC/OS/CS/94/2022 B and is hereby struck out. Cost of 250,000 to the appellant against the first respondent. The implication of this is that the suit filed by PDP was struck out by the Court of Appeal, and of course, by implication, the judgment, of course, was also struck out. That means PDP never brought any action, and there was no judgment. There was no order, no consequential order, or the Court of Appeal did not even consider the issue that borders on reinstating the sacked chairman and councillor. It was never considered by the Court of Appeal, and there was no order in respect of those issues, because according to the Court of Appeal, it is academic, and they are not prepared to venture into same. So the implication now is that the chairman remains sacked, the suit is struck out, and the judgment, of course, is also set aside. But now it is expedient at this point that I refer the House to the Federal Court decision in suit number FHC/OS/CS/103/2022 between Action People's Party, APP, and Independent National Electoral Commission, INEC, and 6 others, wherein the Federal Court held thus at, just 1 minute, it was a judgment in rem, where the Federal Court at pages 47 to 48 held us. Furthermore, in the exercise of the power conferred on me by section 6A and B of the 1999 Constitution as amended, I hereby make the following consequential orders. 1. The election into the local government council across Osun State, held on 15/10/2022, pursuant to notice of election, issued on 15/8/2022, is hereby declared unconstitutional, invalid, null and void for violation of the Constitution and breach of sections 28, 29, 32, 98, and 150 of the Electoral Act 2022. Then 2, all persons or individuals occupying offices in the state local government council by virtue of the said election are accordingly sacked from holding such offices. 3, sections 25 and 26 of the Osun State Independent Electoral Commission Law 2022 having been enacted in contravention of paragraph 12 of the part 2, second schedule to the Constitution, and being inconsistent with section 29 and 32 of the Electoral Act 2022 are hereby struck down. The above is the verdict of this court. Now, this judgment is a judgment in rem that binds everybody, including all political parties in Osun State and even Nigeria, that are eligible to participate in the election, OSEC election of 2022. It's a judgment in rem, and it's still subsisting. And also, of course, it's also expedient that I also draw the attention of the gentlemen of the press to the decision of the Court of Appeal on the 13th of January 2025 that dismissed the appeal filed by the APC against the judgment of the Federal Court in the APP's judgment. So as it is now, the judgment of the APC is subsisting, and it's a judgment in rem. The sacked chairman and councillors that were sacked by the 2 Federal Court judgments still remain sacked. there's no decision of any court of law restating them back to office, contrary to the misinformation that is being expressed in the public. But I also want the gentlemen of the press to also take note that assuming there was any order, the beneficiary of the judgment knows what to do. They will approach the court to try to enforce it by bringing contempt proceeding against whoever that is stopping them from enforcing same. So if at all there was any, they should not resort into self-help, because the rule of law and the rule of force are mutually exclusive. Governor of Lagos and Ojubu is a very is translation of law, and owners of Christ Apostolic Church and Arulei is very, very, is strict. So assuming they had any case, they should approach the Court of Appeal for an order of commuter and to enforce. There's nothing to enforce. Thank you, gentlemen of the press.
What has been reinstated by the Honorable Attorney General and Commissioner for Justice, my brother, Oluwole Jimebada. But I want to play devil's advocate of what they have been saying. Their own argument is that the Court of Appeal is superior to the Federal High Court. And that judgment, the appeal having been allowed, has restored them. Let us go by their own arguments. That judgment, as far as the judgment given in respect of PDP case is concerned, is valid, and that judgment is no longer in existence. There's no argument about that one. However, either rightly or wrongly, the Court of Appeal did not make any consequential order. And the ground upon which the appeal against the judgment obtained by the PDP is that the originating summons with which the PDP applied to the court was incompetent because it discloses no cause of action. The Court of Appeal did not go into the merit of the case. What was the merit of the case? The merit of the case is the validity or otherwise of the notice given, which the Court of Appeal did not determine. And since there are two separate judgments, one obtained by the PDP, yes, annulled. Another one obtained by the APP. The two parties are different. The two judgments with two different suits. The two suits were never consolidated at the Federal High Court. The Court of Appeal gave the two judgments in different dates. And so the two judgments stand, and from the two judgments, the election were annulled. And the council chairman and the councillor, they were asked to vacate. Now, assuming, going by their own argument, the PDP case and the judgment in respect of it has gone. The one obtained by the APP, and if you could recollect, the APC appealed the two judgments. They did, knowing fully well, the two judgments as force of law. Now, looking at the case of APP, they didn't see how they would prosecute the appeal because the APP filed the case after the notice has been published. So they didn't get enough argument to push it forward. So they deliberately abandoned the case, the judgment obtained by the APP. They pushed that of the judgment obtained by the PDP because they find a lacuna that this case was actually filed before the notice was published. So if we agree with them that the judgment in respect of the case of PDP obtained by the PDP has gone, the judgment in respect of the APP, which they filed the appeal and they abandoned, and the Court of Appeal struck out the appeal, becomes subsisting. You cannot pick and choose. So all the arguments as per the case of a PDP, yes, they are right, but they will always be silent on the case and the judgment of APP, which is subsisting. My learned friend, Honorable Attorney General, said the judgment is a judgment in rem. What does it mean? The meaning of that one is irrespective of the party in that case. The judgment of the court that sacked them is valid and enforceable. It's not as if because the PDP is not the party there. It's not about who is the party. It's about the judgment that has been delivered by the Federal Court. We want you people to understand this thing so that you know that we are on a firmer terrain. And let us now see the consequence. Let us agree they now go to the council. They will be guilty of 3 things. First and foremost, they will be guilty of disrupting the public peace. Secondly, if they get to a local government and do anything funny there, they will be guilty of destruction of public property. And the third one, they will be guilty of contempt. And we want the whole world to know that they should not test the will of this government. Any one of them that dare and try to go to any of our local government, we will file contempt of court before the Federal Court. We will now expect them to bring the Court of Appeal of a different suit to come and defend it. So we are warning them now, as stated by our governor, that we know our president to be a Democrat and somebody who respects the rule of law. We know that wise counsel will prevail. Thank you very much.